first, okay. So the very first part of your entrance exam focuses on business laws, wherein Indian Contract Act, both Part 1 and Part 2, Sale of Goods Act, Consumer Protection Act, and some part of Companies Act is given. If you meticulously observe the syllabus copy, the syllabus of entrance exam confines to old laws. That is, your Companies Act 2013 is not reckoned by the university. Still, it is showing Companies Act 1956, though we try to deliberate something on Companies Act 2013 as well, if time permits. Similarly, if you see Consumer Protection Act, still it is showing 1986 Act, though we have new Consumer Protection Act. So with this note, let us make a beginning. Friends, you all are conversant with the fact that law is a body of knowledge designed and applied by the state in the administration of justice. So most of the modern laws in modern India are winnowed from Britishers. The colonial rulers left many vestiges for us of those. Our legal system, our judiciary system is one, still lingering behind the rustic provisions. Unfortunately, we can't comment on that. So most of the case studies, most of the legal lexicons which we come across in our textbooks, in our literature, replicates the British terminology and, of course, the British case laws either. So Britishers have ramified law into two parts. One is criminal law, another one is civil law. Criminal law functions on the premise of crime and punishment. On the other hand, civil law works on the premise of dispute and settlement. So, you know, commerce students, may I request some of you please mute yourselves? I'm getting crosstalk, don't mind. Well, civil law emphasizes on dispute and settlement. When we speak about commerce, trade, business, or industry, naturally, disputes and their settlements occurs in every stage. So we need to have a code of conduct to settle those disputes. So obviously, business law comes into picture. So it's very much implied from this that business law falls in the ambit of civil law. So lion's share of business law covers Contract Act, Sale of Goods Act, Consumer Protection Act, IPRs, of course, Environmental Protection Act, and Companies Act. Now, Companies Act is reckoned as corporate laws. Let us keep it aside for time being. Now, only focus on business laws, of which the lion's share is occupied by Indian Contract Act 1872. If you see Indian Contract Act 1872, when it was designed, it had 266 sections. But in 1930, may I please request some of you, please mute yourself. Right. In 1930, we have separated Section 75 to 123 into separate law called Sale of Goods Act 1930. Similarly, from Section 238 to 266, we have separated into another act called Partnership Act 1932. So now we have Indian Contract Act from Section 2 to Section 74 in Part 1 and Section 124 to 238 in Part 2. Right? So why Section 2? Why not Section 1? Section 1 reads like this. This act applies to whole of India except the state of Jammu and Kashmir. Now, don't you think that this provision is nullified? Because the special status granted for Jammu and Kashmir is done away recently by Parliament of India. Therefore, Section 1 of Contract Act doesn't have any validity in the eyes of law now. So we have to understand only from Section 2 to Section 74 in Part 1 and 124 to 238 in Part 2. So 124 to 238 deals with special contracts. There are 5 types of special contracts formally recognized under Indian Contract Act, namely contract of indemnity, contract of guarantee, contract of bailment, contract of pledge, and of course, contract of agency. These 5 contracts from 124 to 238 sections are formally known as special contracts. On the other hand, part 1, which we are going to emphasize now, that is from section 2 to 74, discusses the general provisions governing the contracts. So, it's obvious that you would have forgotten the definitions of contract because you dealt with this subject in previous semesters. So it's obvious that you forgot some basic tenets. So we understand law in 3 different facets. That is the formal definitions based on which the entire jurisprudence works. Second, the sections which are quoted by the solicitors or the lawyers or the practitioners of law. And third, the appropriate case laws. These 3 are the standing facets of any law. And same holds good for Indian Contract Act either, right? Now, owing to time constraints, I will not dwell into the definitions of part 1 or part 2. It consumes a lot of time. Rather, I will try to give only brass tacks of the subject. When I see what is contract, obviously we understand that it is an agreement enforceable by law. So contract has got 2 terms. One is an agreement and another one is enforceability. What is agreement? Sorry. For a layman, agreement is simply an understanding between 2 parties to do something, isn't it? But you are students of law. So you need to understand the section of Contract Act in which agreement is formally defined. Section 2, subsection E defines that every promise and every set of promises forming consideration to each other is an agreement. That means one person makes a promise, another person makes a reciprocal promise. If these 2 promises are supported by consideration, that means mutual benefit to both the parties, it's an agreement. If such agreement is enforceable by law, it's a contract. Sir, what is enforceability then? Friends, enforceability is nothing but legal recognition. That means you and I have some agreement. If either of us have some dispute, we would be in a position to go to court. Then court will formally recognize, yes, there is an agreement between you. So we are entertaining your complaint. We are entertaining your dispute for settlement purpose. So law should recognize that there is an agreement between you for settling any dispute. That is called enforceability. Simply enforceability is the recognition in the eyes of law. So if your agreement is recognized in the eyes of law or on the grounds of law, it's a formal contract defined in section 2, subsection H of Contract Act. An agreement enforceable by law is a contract according to section 2, subsection H. Sir, we don't know all these technical jargons. Then you can simply say that an agreement is a consequence of offer and acceptance. That means offer plus acceptance is equal to agreement. Agreement plus enforceability is equal to contract, right? Now the question is, when an agreement is enforceable in the eyes of law. Suppose I have an agreement with you that I will give a party to you tomorrow evening and I could not keep my promise. Can you go to court against me? Obviously not, because this agreement is not enforceable by law. It's not a contract. Why it is not enforceable, sir? Rather, the question is, when an agreement gains the status of enforceability, let us see. There are 10 essential elements which every agreement should fulfill. Only then it becomes a contract as an enforceable agreement. So what are those 10 essential elements? Let us see now. Each essential element forms the core of your business law. 1, there must be 2 parties, that is offerer and offeree. Offerer is a person who initiates the process of forming a contract. In simple sense, contract is the brainchild of an offerer. It is he who conceives the idea of forming a contract. It is he who initiates the process of forming a contract. And obviously, the other party is offeree with whom you want to make contract. So once contract is finalized between offerer and offeree, they both shall respectively become promisor and promisee. There must be two parties, promisor and promisee, or simply offerer and offeree. Right? Second, there must be lawful offer and acceptance. What is offer, my dear friends? According to section 2, subsection A, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of such another, is said to have made an offer. That means either to do a particular thing or to abstain yourself. That means to restrain yourself from doing a particular thing. If you make a proposal, that proposal is called an offer within the purview of section 2, subsection A. This offer is of 5 types. General offer. An offer made to public at large is called general offer. Tomorrow in entrance exam, he may ask an MCQ question like this. An offer made to public at large is called dash. It's a general offer to which anyone can give acceptance. Hope you all remember the famous case Carlyle versus Carbolic Smoke Ball Company Limited. I don't dwell into that case now owing to time constraints. Second is special offer. An offer made to a special person, a specific person, is called special offer to which others cannot give acceptance. So 99.9% of the offers which we come across in contracts and businesses are special offers only. Third is cross offers. So plural I am using cross offers. What is this? When two identical offers, that means when two same offers are exchanged between the parties in ignorance, they are called cross offers. For example, I am writing a letter to you. Mr. X, will you sell your house to me? You don't know about that. You are also writing a letter to me. Mr. Suresh, will you buy my house? So I am asking, will you sell? You are asking, will you buy? So don't you think content is same? So they are identical offers exchanged between the parties in ignorance. They are called cross offers. They will not form any contract, right? So two identical offers exchanged between parties in ignorance are called dash. It's cross offers. Fourth one is counter offer. What is this counter offer? When one person encounters the offer with another offer, or a person gives conditional acceptance to your offer, it is called a counter offer. For example, I am asking you, will you buy my house at Nacharam for 2 crores? You received my letter or my offer letter. You are giving a reply. I will buy your house at Nacharam for 1 crore, provided you buy my chicken shop at City College for 2 crores. So what is happening here? You are encountering my offer with another offer or putting condition therein. So it is not a valid offer, right? So counter offer is invalid. Remember this point very carefully. It may come in examination. If one offer is encountered with another offer, or if offer is subject to conditional acceptance, it is called dash. It is called a counter offer. It is not valid. Fifth one is tender. Tender is also an offer, my dears, but it is submitted in response to invitation to offer. Clear? Suppose government wants to construct a flyover. What it does, it will give invitation in the newspapers. So our specifications are this. Whoever contractor is interested, submit your tenders, submit your biddings. So if it is acceptable to us, we will give acceptance. So contractors will submit their biddings or something called tenders. So tender is also an offer, but submitted in response to invitation to offer. Remember this. So what is the offer that is submitted in response to invitation? Called tender. Clear? So among these 5, only general offer and special offer are valid. Of course, tender is also valid, whereas cross offers and counter offers are invalid. Clear? That's about offer. And I said you, there must be valid acceptance also. What is acceptance? In legal text terminology, acceptance is called promise. According to section 2, subsection B, acceptance, or when the person to whom proposal is made signifies his assent thereto. The proposal becomes promise. Simple way. If you make a proposal to me and unconditionally I am giving acceptance, unconditionally, I am using this word, please. Unconditionally, I am saying yes, then only it becomes legal acceptance or lawful acceptance. Clear? So, if acceptance is subjected to condition, it is called dash. It is called counteroffer. So simple. So section 2A defines lawful offer, 2B defines lawful acceptance or lawful promise. They must be there. That is the second point. Third, there must be lawful consideration. What is this consideration? Quid pro quo. That means something in return. If I am performing my obligation in the contract or discharging my duty in the contract, I must get back something in return. That must be some material benefit. It must be measurable benefit. That is called consideration. For a layman, consideration is nothing but benefit derived from contract. It is also called quid pro quo. It's not called exactly. It's derived from this Latin legal practice called quid pro quo. That is something in return. This term consideration is defined in section 2, subsection D of Indian Contract Act, D for Delhi. So definition is very lengthy one. I don't see the definition now owing to time constraints. I told you earlier. Simply remember, consideration is the benefit defined in section 2, subsection D of Indian Contract Act. It is derived from quid pro quo, right? So without consideration, contracts are void in the eyes of law, invalid in the eyes of law. Section 25. Section 2, subsection D defines what is consideration. But section 25 states that agreements without consideration, agreements without benefit are invalid from the beginning. Section 25. But there are some exemptions to that. What are those exemptions? For example, agreements made with natural love and affection. For example, father and son, father and daughter. Natural love exists between them. And such agreement is duly written as a will. In Telugu, what you call virunama. So it is enforceable even though the writer or executor of the will doesn't get anything in return. Right? For example, I write like this. After my death, my entire property should go to my daughter. So daughter is not giving anything in return, but still it is valid in the eyes of law. She can get back my property once I'm deceased. So that is enforceable. Similarly, promise made to clear the time-bound debts. Similarly, promise made for compensating services rendered in the past. Example, pensioners are drawing pension. Government cannot say, no, we are not getting anything in return, so we won't give you pension now. It cannot say because it's a promise you made to compensate the services rendered in past. So it's valid though government is not getting anything in return. Similarly, agreements of agency, contract of agency is enforceable even without consideration. Charitable subscriptions are also enforceable even without consideration. So in all other cases, except these 5 cases which I told you, contracts are enforceable or agreements becomes contracts only when there is a lawful consideration. That is third essential element, my dear friends. First one is there must be 2 parties, promisor and promisee. There must be offer and acceptance, which are lawful. Second one. Third, there must be lawful consideration. And I told you what is consideration and what are the 5 cases where agreements are enforceable even without consideration. Fourth, there must be lawful objective. What is the difference between objective and consideration? See, consideration is the benefit which I derive, and objective is the purpose of contract. I will give a small example. For example, I have an agreement with you. I will let out my house to you on rental basis, say 20,000 rupees per month as rent, provided you run a gambling house in it or you run a casino in it. So, what is there? Receiving 20,000 rupees of rent is consideration. But the purpose for which it is taken is running a gambling house or a casino, which is invalid, which is unlawful objective. Then it's a unlawful contract or not a valid agreement. So what I try to connect with you is that agreement must have both lawful benefit to the parties as well as lawful purpose of the parties. So both consideration and objective must be lawful. That is fourth one. Of course, there are so many essentials defining what is lawful objective, which is out of the scope of your MCOM entrance test. So I'm skipping it intentionally here. Next, capacity of parties to contract. Fifth one is capacity of parties to contract. Capacity means competent. Who are competent? What is the difference between competency and eligibility? Usually you see these HR managers, no? We want to test the competencies of students. So they want to see the skills of the students. So in strict sense, skills are different from competencies. Skills are only adroit or dexterity that you have to do a particular work. Your ability to do the work is called skill. Whereas competency is nothing but legal eligibility, which is different from skill. Simple example I will give. A compounder working in hospital may have skill to prescribe medicine, to prescribe treatment, because he's working for the past 20 years or 30 years in the medical field. So with that rich experience, his skills knows what type of medicines to be given. But only a qualified MBBS doctor is competent to prescribe medicine. Now you got the point. Competency is legal eligibility. Skill is only ability. So what here I'm trying to connect with you is, my dears, you need to have legal eligibility. The party who is trying to enter into contract must have legal eligibility. Now the question is, who are competent? Who got that legal eligibility? Let us see. First, you must be major by age. Who is a major? A boy or girl under normal circumstances who completes the age of 18 years is a major for the purpose of entering into contract. Remember, matrimonial majority is different. Business eligibility or business majority is different. For matrimonial majority, girl 18 years and boy 21 years. But irrespective of the gender, what our business laws, what our contract act says is, if a person completes the age of 18 years under normal circumstances, becomes a major for the purpose of entering into contract. But please try to understand one point here, which you don't find in the textbooks, my dears. If parents are died, that means if natural parents are died and the minor is being brought up under the custody of a loco parent, that means your chinnana, pedana, like that, or under the court guardian, then he or she obtains the age of majority only after completion of 21 years, but not 18 years. If parents are alive, happy, no problem. 18 years is over, you are major to enter into contract. But if parents are died, he or she is brought up under loco parent custody, then 21 years must be lapsed in order to obtain the age of majority. You must be major by age to become competent. Second, you must be of sound mind. What is sound mind here, my dears? Sound mind is nothing but the mental status that enables a person to prudently understand the work which he is doing, right? So whatever work you are doing, that must be in your cognitive mind or mental sphere. Only then you are of sound mind. So here, law puts three important aspects for examination. One is idiocy. Second is lunacy. Third is intoxication, right? Fourth, of course, insaneness is there, that I will keep aside for time being because there are some controversies on that. First is idiocy. Who is an idiot? It's Ravi Teja sir cinema. No, it's not like that. See, idiot means a person suffering with permanent mental disability. So if anyone scolds you idiot, that means you are permanently mental disabled. Don't accept that scolding, please. Right? So idiocy means permanent mental disability. A such person can never enter into contract in his lifetime. Second, lunatic. Who is a lunatic? Lunatic is a person who suffers with the intermittent intervals of sound mind and unsound mind. That means sometimes his sound mind and sometimes his mind doesn't work, right? Due to special circumstances or special conditions. Simply speaking, lunatic is a person suffering with temporary mental disorder, which can be cured by putting him in lunatic asylum. Your Eragata lunatic asylum is there, right? So once doctor certifies that his lunacy is cured, then he can enter into valid contract. Until that, his unsound mind is not competent to enter into contract. Third is intoxication. For example, the time of signing an agreement, if you are drunk or subjected to opium or some drugs or sedatives, then the agreement signed by you is invalid. Tomorrow you go to court and say, sir, I was drunk at the time of signing agreement. I did not know what did I sign, where did I sign. So please forgive me, absolve me from the liability of this agreement, sir. Then honest of proof is vested in your hand only. You have to prove in the court that I was intoxicated, I was drunk, I was under drugs or opium at the time of signing agreement. Only then court will excuse you from performing that agreement. So these 3 points to remember: idiocy, lunacy, and intoxication. You should not be suffering with this. Clear? So if you are not suffering with either of these, your sound mind, you can enter into contract. One is you should be major by age. Second, you must be of sound mind. Third, you should not be an insolvent. Previously, we had insolvency acts. Now we have simply called IBC, Insolvency and Bankruptcy Code, right? So either due to previous laws or present law, if you are declared as a financial insolvent, an insolvent, what we call in Telugu, Diwala Koru. So you cannot enter into any contract, right? So who is an insolvent? You all know. A person whose total assets are less than total liabilities, and by any cost he is not in a position to repay the liabilities, then court will take over his property and declare him as insolvent. If you are declared as an insolvent, you cannot enter into contract until you obtain solvency certificate. That means you have to clear the debts, go to court, plead there that I am solvent now, please declare me as a solvent. Then you can enter into contract. So for time being, you remember that insolvent is not formally entitled to form a contract. Clear? Next, of course, foreign ambassadors. Who is a foreign ambassador? A person who represents his country abroad. So if he does any mistake, if he does any, cumbersome issues or involved in any legal entanglements, it's a remark on entire nation which is representing. Therefore, what our law says is that foreign ambassadors are not legally eligible for commercial contracts, but they are eligible for social contracts like marriages that we'll see when time permits. Simply remember in business law that insolvents are not foreign ambassadors are not eligible for forming contracts, commercial contracts. Similarly, convict. A convict is a person whose guilt is proved and court has formally declared him imprisonment. So until completion of imprisonment, you cannot enter into contract, right? See, remember, convict is different from accused. Sometimes accused may be put in jail, though conviction is not proved, though allegation is not proved. For example, your APCM, Jagan was in jail for 16 months as an accused. So he could enter into contract, he could run Sakshi paper, he could run Bharti Cements. Why? Because he's still accused. He's not incompetent to enter into contract. But once court finalizes the punishment, yes, your guilty is proved, we are imposing 5 years of imprisonment to you, then he or she cannot enter into contract. So convict is a person whose accusation is proved in court and imprisonment is formally imposed. So convict cannot enter into valid contract. And of course, any other persons like allied enemies. Allied enemies means enemy of the nation. He cannot enter into contract. Now, if a question comes to you tomorrow in the MCOM entrance exam, who among the following is incompetent to form contract? A, minor. B, insolvent. C, allied enemy. D, all of the above or all of these. Your answer would be obviously D, all of these, because you learned it now, right? So these aspects we need to understand with respect to incompetency or competency of parties to enter into contract. Remember, we are still discussing the essential elements of valid contract, wherein we understood that there must be two parties, there must be lawful offer and acceptance, there must be lawful consideration, there must be lawful object. Fifth one, which we dealt with, is that the parties to contract must be legally competent. That is major, sound mind, not an insolvent, not a convict, not a foreign ambassador, not a allied enemy of the nation, right? Sixth essential element, there must be consensus ad idem. What is this consensus ad idem, my dear friends? It is nothing but mental agreement between two parties. In simple sense, both offerer and offeree should understand the subject of the proposal or agreement in same sense and in same manner. That is called consensus ad idem, right? I will give simple example. I'm sorry if I'm deviating. It's a bit mischievous example rather. In order to make it clear, I am taking this example. Suppose you and your friend want to elope from Hyderabad. You ask your friend to come to Sentence 10 o'clock. Sentence College, you come at 10 o'clock, put off the cell phones because police people will trace us through towers, mobile towers and all. So let us meet at Sentence College 10 o'clock. So your girlfriend came to Mehdipatnam Sentence. You are waiting at Secunderabad Sentence. Is there consensus added in between you? No. So day one you could not meet. You went back to your respective homes. Next time you planned. This time, Pakka, we both are meeting at Mehdipatnam Sentence, sharp 10 o'clock. Done, deal okay. Your girlfriend came to Mehdipatnam Sentence morning 10 o'clock and you came at night 10 o'clock. What happens? Agreement breaks, revocation of agreement. That means you both do not have consensus ad idem, my dears. Same holds good for contract either. Both offerer and offeree should understand the content of agreement in same sense and in same manner. That is called consensus ad idem. That must be fulfilled. Consensus ad idem is not legally defined anywhere, but it is understood from the jurisprudence, the judicial literature, right? Next, of course, the agreement should not have been specifically declared void. What is void, void, void? Every moment I'm calling void, void. Void means invalid. Friends, there are 6 cases, 6 agreements, which our Indian Contract Act specifically declares to be void, specifically declares to be invalid from the beginning. What are those? Number one, agreements without consideration are void, section 25. Next, second, agreements in restraint of marital liberty are void. That means if your agreement is restricting the marital liberty to marry, it's a invalid agreement. Suppose a director signs an agreement, a cinema director signs an agreement with a heroine. So I am taking Bahubali 4. So it may take 3 years or 4 years, I don't know. Until the completion of movie, you should not get married. His worry is that if she gets married, becomes pregnant, she can't act as a heroine. So he writes an agreement. Until the completion of my shooting, you should not get married. Meanwhile, she got married and left. Can the director go to court against the heroine for compensation? No, he cannot, because section 26 clearly says that any agreement restricting the liberty of marriage is invalid from the beginning. That is section 26. Section 27, agreements restricting trade liberty is invalid. What is this? For example, you say, I am having quotation here, you don't come into my area. I'm having my shop here. You should not do business here. So you are restricting my trade liberty. It is invalid, except in the case of goodwill paid to outgoing partners. We generally pay goodwill like this. So don't carry this business for 3 years in this area. For that, we are taking 3 years of super profits as goodwill to you, right? So in that case, if you are restricting the trade liberty of outgoing partner, it is valid. But in other cases, liberty of trade cannot be restricted. So any agreement restricting trade liberty is invalid. 27. Similarly, 28. Agreements in restraint of legal proceeding is invalid. Void. Suppose you write an agreement with the customer like this. My dear customer, whatever dispute we have, you must come and settle at our office only, or you must come and settle it at Pedaraidu or Chunaraidu. You should not go to court. No such agreement is recognized in the eyes of law, my dears. Of course, there is one law called Arbitration Conciliation Act 1996. There, arbitration, that means parallel courts. Outside the court, we can go for judgment. Settlement of dispute. That is, of course, out of the purview of your syllabus. I will keep aside. Generally, in general, agreements cannot restrict the liberty of taking legal action. Section 28. Section 29. Agreements with uncertainty are invalid. That means any agreement having no clarity of terms and conditions is invalid. That's the reason why you see any house document or stamp papers which your parents hold in your hands, definitely it will run into 3 or 4 pages or 5 or 6 pages. So vendor, vendee, hereinafter called party. So everything will be clearly, detailedly mentioned. Why that mentioning is given? Because if terms and conditions are not clearly mentioned according to section 29 of Indian Contract Act, such agreement is invalid in the eyes of law. So void ab initio. Void ab initio means invalid from the beginning. Right? Section 29. And the last one, section 30, is betting agreements. Wagering agreements are invalid, except in the case of licensed lotteries or licensed horse races. So all betting agreements or wagering agreements are invalid. Tomorrow he may ask a question to you in the MCOM entrance exam. What is betting agreement? A valid agreement. B, a wagering agreement. C, a voidable agreement. D, none of this. So your answer must be B, wagering agreement. Nothing but betting agreement. It is invalid in the eyes of law. Clear? So what I am trying to connect you is that your contract should not fall in either of these 6 cases. Clear? And now let us come back. We need to have 2 parties. We need to have lawful offer and acceptance. We need to have lawful consideration. We need to have lawful object. And the parties to contract must be competent legally. There must be consensus ad idem. The contract should not have been specifically declared void under Contract Act. That is from section 25 to section 30. Next, of course, agreements with uncertainty, agreements with vagueness or void, right? That means I told you earlier that any agreement having no clarity is invalid. But separately we will discuss. And of course, any agreement wherein free consent is lacking is invalid. Very, very important, my dear friends. What is free consent? For examination purpose, you may ask it. See, free consent is formally defined in section 14(1)(4) of Indian Contract Act. It says like this: the consent which is not induced by coercion, undue influence, fraud, misrepresentation, and mistake is only a free consent. So if either of these 5 flaws are there, flaw, F-L-A-W, flaw means legal defect is there, then it is not a free consent. What is coercion? You all know coercion is blackmailing someone, threatening someone. It has got a lengthy definition. For example, according to section 15 of Indian Contract Act, coercion is committing or threatening to commit any act forbidden by Indian Penal Code 1860, or any unlawful detaining or threatening to detain any property to the prejudice of any person, whatever with the intention of causing such a person to enter into an agreement. Nothing is understood, sir. Obviously, your teachers would have told you long back and you forgot. It's common phenomena. That's why I told you, I gave a caveat in the beginning that I'm not going to grope the definitions at this juncture. So simply remember that coercion is defined in section 15. It's a flaw of consent. It's a defect of consent. Next, undue influence. What is this undue influence? See, there are two parties such that one party is in a position to dominate other party and uses that dominating position for unfair advantage. Say, for example, doctor and patient. Doctor knows that particular disease can be cured with medicine, but he threatens the patient. Arey, poor fellow, you will die unless you go for surgery. The poor patient, what he does, he will listen to doctor because doctor is in a dominating position and doctor is misusing that position to gain advantage. He knows that medicine is sufficient, still is preferring surgery. So he's applying undue influence. If you prove it in the court of law, you can claim compensation, my dears. Right? So undue influence is defined under section 16. Next, fraud, section 17. Misrepresentation, section 18. And of course, 20 and 22 defines mistakes, unilateral mistakes, bilateral mistakes. So if either of these 5 defects are there, it is not a free consent. Clear? And the last essential elements of valid contract is technical formalities. For example, government says agreement will be enforced in the eyes of law only when it is registered on a stamp paper, or minimum 2 witnesses are required, 2 signatures of witnesses are required. Such formalities can be imposed by governments from time to time. They must also be fulfilled. Only then contract becomes valid in the eyes of law. Only then agreement becomes enforceable by law. All these 10 essential elements must be fulfilled, my dears, right? So with this, what is lawful contract? What are the essential elements of lawful contracts? Of course, each essential element we took as a separate concept are done away. Now let us see how many types of contracts we do have, my dears. See, contracts can be classified into 2 categories: absolute contracts and contingent contracts. Let us first see contingent contracts. What is contingent contract? Contingent contract is defined in section 31 like this: a contract to do or not to do something if some event collateral to such event does or does not happen. Did not understand, sir. The classic example for contingent contract is insurance contract. The best example. For example, I have purchased a 2-wheeler and I entered into contract with, say, Birla Sun Life Insurance Company or say ICICI Lombard Insurance Company. What is that agreement? If my vehicle meets with an accident, only then responsibility of insurance company comes into picture. Otherwise, they won't take any responsibility to make compensation or pay any amount to you. So, insurance contract is the best example to illustrate contingent contract. If some unforeseen future event happens, then only the responsibility of the party of contract comes into existence. Otherwise, no. It's a contingent contract in section 31. And my dear friends, section 31 to 36 defines the terms of contingent contract, which are not required to you for appearing MCOM entrance exam. So I will not dwell into that. Now, let us come to second part, that is absolute contracts. Absolute contracts are the cases where parties have to perform the obligations irrespective of the future consequences. Whatever is the future consequence, but you have to perform your obligation because you signed agreement. That is called absolute contract. So how many types of absolute contracts are there? See, I have got 4 important classifications of absolute contracts. For that matter, in any textbook, any standard textbook or reference book, you can see these 4 classifications. 1, classification of contracts on the basis of validity. 1, valid contract. Already you learned it. All 10 essential elements must be fulfilled in it. An agreement enforceable by law, section 2, subsection H, is called a valid contract. Second, void contract. Section 2, subsection J defines what is void contract. What is this? J for Jeep. A contract which ceases to be enforceable by law becomes void contract. That means at the time of formation of contract, it is valid, but before its performance, it becomes invalid. It is called void contract. More often than not, students get confused that void agreement and void contract are same. No, my dears. There is absolute difference between void agreement and void contract. See, void agreement is defined in section 2, subsection G. What it says, an agreement invalid from the beginning, right from the moment of formation of agreement. If it is invalid, it is called void agreement. But void contract is valid in the beginning, but loses validity at a future date. It is called void contract. So tomorrow, if question comes in your MCOM entrance exam, any agreement which is invalid from the beginning is called dash. Options will be given to you. A, void agreement. B, void contract. C, voidable contract. D, none of this. Your answer should be obviously A, void agreement, which is invalid from the beginning. From the moment you form it, it is a invalid. So void contract is different from void agreement. Third one, voidable contract. What is this voidable contract? A contract which is enforceable at the option of one or more of the parties thereto, but not at the option of other or others, is called a voidable contract. Nothing is understood, sir. No problem. Let us make it simplified. In section 2, subsection I, we have this definition. Forget about this definition. We simply remember the section. Section 2, subsection I defines voidable contract. What it is? See, in any contract, one party would be aggrieved. One party will be victimized. Such victimized party will have option. Chalo bhai, contract ho gaya na, let us go ahead with that. Or else that victim can go to court. No, sir, I am victimized, I am aggrieved, I am deceived in this contract by other party. So permit me to cancel this contract and claim compensation. Such type of contract is called voidable contract. Okay. In any contract wherein one party is deceived or aggrieved is called dash. Or simply question may come like this. A contract which is enforceable at the option of only one party is called dash. Your answer should be voidable contract. Got, my dears? Next, of course, illegal contract. The term illegal contract is nowhere defined in law. Very surprising, right? We talk about so many brass tacks, so many tenets of law, but we did not define what is law illegal contract. Simply remember, according to the provisions of section 23, a contract, there is some crosstalk. Am I audible, my dears? Sir, can anyone confirm I am audible? Okay, let me go ahead. All right. So, hello, am I audible? Hello there.
Yes, sir, you're audible.
Okay, ma'am. Thank you. Thank you. I had some problem here. That's why I'm cross-checking. Doesn't matter.
There's a network issue, so no problem, sir. Carry on.
Thank you, ma'am. Thank you. Thank you. I'll go ahead. So, you understand from section 23 that any agreement, the subject matter of which is either partially or completely forbidden by law, it is illegal contract. That much we need to understand. There's no formal definition. So, first classification of absolute contracts is done. Valid contract 2H, void contract 2J, which is different from void agreement as different in 2G, voidable contract 2I, illegal contract, no section, but we imply it from section 23. Clear? Now, second classification of contracts is classification on the basis of formation. How contracts are formed. On that basis, we have three categories: expressed contracts, implied contracts, quasi contracts. Some new textbooks, if you read, my dear friends, like your SIA publications or Rahul publications, what these books or what these authors are writing is e-commerce contracts as a separate category. But I don't recon that. I don't consider that because e-commerce contracts are very much expressed, isn't it? They're expressed in digital format. Therefore, they also fall in the ambit of Section 9, subsection 2 of Indian Contract Act as ruled by Supreme Court in the case of Amazon. When Amazon had a dispute with Government of India, so then Supreme Court clearly said e-commerce contracts are not separate. They're also part of expressed contracts. So based on formation, I bring only 3 contracts to 4 for discussion. One is expressed contract. What is that expressed contract? Contract which is expressed in words spoken or written is called expressed contract. What is this, sir? Contracts written are valid. We know that. Even words spoken will form contract? Yes, please. See, when call centers are making call to you, especially the BPOs are making calls to you and binding you with the contract, binding you with the agreement. If you blindly say yes, yes, okay for me, go ahead, then they will keep your yes word as an evidence. Remember, you take any BPO, it may be Zenpact, it may be Bank of America ZPO, Quantum Solution, whatever BPO you take, the customer voice cards or voice records will be preserved for 2 years because they will take it as evidence. When you say, no, I did not sign any agreement, they will show your voice call as an evidence. So even words spoken will also form a contract, provided there is an evidence to substantiate your spoken words. So simply remember that words spoken or written forms expressed contracts. Next, of course, implied contract. Section 9, subsection 1 defines what is implied contract. Insofar, contracts formed with other than words spoken or written. That means neither you spoke anything nor you wrote anything, but contract is formed with your actions. It is called implied contract. Suppose a question may come to you in the MCOM entrance examination. Contract formed between public transportation bus and a passenger by buying a ticket is called dash. A, expressed contract. B, implied contract. C, others. What do you write? Obviously, it's an implied contract because neither I nor RTC had an agreement in writing. Simply my action of buying a ticket creates contract between me and RTC, isn't it? That is called implied contract. Section 9, subsection 1. Next one, of course, quasi contracts. What is this quasi contract? Contracts which are not created by the parties themselves. You and I did not sign any agreement, but law or court will impose some contractual responsibilities between you and I. That is called quasi contract. These quasi contracts are also known as constructive contracts, right? If someone asks a question to you tomorrow in the examination, quasi contracts are also known as dash. The answer should be constructive contracts. See, from section 68 to 72 of Indian Contract Act explains quasi contracts. Section 68 says necessities supplied to minor can be recovered under quasi contracts. You all know by this time that minor cannot enter into contract. But if you supply any necessity like food, shelter, clothing, you can recover it though he is not competent to form contract from his estate if possible. That is section 68. So law is permitting you, though there is no contract between you and minor. That's a quasi contract. Similarly, section 69, reimbursement of the payment made in good faith to protect others' property. In order to protect the property of others, you made some payments. For example, property of your neighbor is caught with fire and you spent some money, brought the fire engine, brought the water tankers and put out that fire. Tomorrow you go and ask him, I have incurred this much expenditure to vanguard your property. Give me this money. Then the owner cannot say, why should I give? Is there any specific agreement between you and I? He cannot say like that because section 69 imposes quasi-contractual obligation. Similarly, section 70, responsibility of person enjoying non-gracious benefit. That means some benefit is not designed for you. It is not at your disposal. but either by mistake or something else, you are enjoying it. So it is your responsibility to compensate the same to actual beneficiary whenever it is sought. Clear? 71, responsibility of finder of goods. See, the person losing goods will not have any agreement with the finder of goods. Arey bhai, I will go on walking, I will lose some goods, you trace it, I will give money. No such agreement will be made. But law imposes obligations that the position of finder of goods is as good as that of a bailee. Bailee is a person who keeps temporary custody of goods, who has to exercise reasonable care to protect the goods. Who says that? Is it said by the loser of the goods? No, it is imposed by law. So obviously it's a quasi contract. And finally, section 72, that is responsibility of person enjoying benefit under a voidable contract. I told you what is a voidable contract already. Voidable contract is a case where one party will be victim. One party is cheated. So the cheated party, the victimized party, go to court and say, sir, I want to cancel the contract. Then court may permit, yes, cancel the contract. Under such circumstances, the victimized party can claim back the benefit given to other party. Right? So the other party cannot say, no, there is no such agreement to give back. I won't give it back. He cannot say, because law says you have to give it back because other party is victimized and we are permitting him to cancel the contract. So these are 5 cases or 5 circumstances which are reckoned as quasi contracts or constructive contracts, my dears. Okay. So contracts on the basis of formation are quasi contracts, expressed contracts, and implied contracts. Now, third category of contracts, that is contracts on the basis of execution, that is work done. Here we have unilateral contracts, bilateral contracts, executed contracts, and executory contracts. Unilateral, name itself indicates, only one party has performed the obligation and other party is yet to perform. It's called unilateral contract. Bilateral contract, both the parties have to execute the contract yet. Only agreement is made. It's called bilateral contract. Next, executed contract is past contract. Already both promisor and promisee have duly performed their obligations. It is called executed contract. And of course, we have executory contract. It's nothing but as good as bilateral contract where both the parties have still work to do in the contract. That is classification on the basis of execution. And final classification is, my dears, on the basis of British laws. I told you, most of the Indian laws are winnowed from British laws. So obviously, we need to understand the classification of contracts under British law either. So here we have simple contracts and formal contracts. Simple contracts is normal mercantile contracts, business contracts, buying goods, buying property, selling property, etc. Right? On the other hand, we have formal contracts. Formal contracts are of 2 types. One is contract under record, another one contract under seal. See, contract under record means judgment given by Privy Council in UK. Privy Council, they're courts, they're the part of the judiciary. So the judgments given by UK courts in the case of civil disputes is called contract under record. In India, though civil dispute judgment comes to 4, we call it as a judgment only. Or maximum we call it as award, but we won't call it as a contract. It's a stipulation essential for us to abide by it. But in UK, in civil disputes, judgment is called contract under record. And of course, on the other hand, we have contracts under seal. Any contract which is vetted by the formal government authentication is called contracts under seal. I really surprised some textbooks writes any contract which is kept in sealed cover, subjected to tender, it's sealed contract. No, it's absolute blatant lie they wrote in the textbooks, my dears. Simply remember now I'm telling contract under seal is nothing but a contract which is formally authenticated by government seal or government stamp is called sealed contract in UK. So forget about that because it's not implemented in India. So this is the classification of contract. Now, after understanding contracts, essential elements and classification, contingent contracts and absolute contracts, Now I will straight away go to very, very important concepts, that is discharging contract and breach of contract. Now let us see discharging of contract. See, you all know that contractual relation is a temporary relation. It has to come to an end once the contract is performed. So there are 5 to 6 different ways in which contract can be discharged. One is by performance, section 37. So if you perform the contract, obviously contractual will be discharged. The contractual relation will be terminated, isn't it? So by performance. Second, by agreement. Sir, I and you had an agreement. Unfortunately, we are not in a position to perform. So let us have new agreement to cancel the old one. Then contract can be discharged. Here we have many types of agreements. For example, novation. According to section 62, novation is the process of replacing old contract with new contract. Obviously, old contract will be discharged. Similarly, remission, accepting lesser performance. That means the higher performance will be discharged. Rescission, cancelling contract altogether it is, not economic rescission here. Here in law, rescission means cancellation. Resigning in Oxford Dictionary means cancelling. Okay. Similarly, waiver, forgiving other party. Chalo bhai, you can't perform the contract, I am waiving your performance. So by all these ways, contract can be discharged. The second mode, discharge of contract by agreement. Third, discharge of contract by impossibility of performance. Impossibility of performance is of 2 types, my dears. Absolute impossibility and supervening impossibility. If both the parties knew in beginning that it is impossible to perform the contract, still they had an agreement, it's nothing but betting contract, wagering agreement. Right from the beginning, it is invalid. But the problem is with second one, supervening impossibility. According to section 56, any contract subject to supervening impossibility is a discharge. It is deemed to be discharged. What is supervening impossibility? Nothing but the performance which becomes impossible at a future date. That means at the time of signing agreement, it is capable of performance. But before tendering performance, it becomes impossible. That is called supervening impossibility. Of course, there are cases when supervening impossibility is a valid excuse and when it is not a valid excuse. That you forget now, because now I am just brushing the syllabus to write your MCOM entrance exam. So you remember that supervening impossibility is discussed under the provision of section 56, which can discharge the contract altogether. This third category. Fourth one is discharge of contract by change in law or operation of law. Suppose a law is changed suddenly, right? Or outbreak of war between 2 countries. My promisee, the other parties in Pakistan, I am in India, we had an agreement. Suddenly, outbreak of war occurs. Naturally, the contract between me and him becomes invalid, becomes void, isn't it? So, operation of law also makes contracts invalid. Similarly, lapse of time. See, very, very important. Section 46 clearly mentioned, 46 and 47 as well. The contract must be performed in the time stipulated, or else within reasonable time as the case is concerned. Otherwise, the contract shall get discharged. So if time is lapsed, contract will be discharged. And final one, my dears, contract discharge by breach of contract or revocation of contract. That is very important for me. So revocation, breach means intentionally you are not performing the contract. You are not performing your duty in the contract. It is called breach of contract. So when I'm revoking the contract, intentionally I'm breaching the contract, not performing the contract, don't you think other parties will have some remedies against me? Don't you think other party will have some rights against me? That is our next topic. What are the remedies of aggrieved parties in the case of breach of contract? What are those? Number one, suit for rescission. That is cancellation. You can go to court, sir. The other party is revoking his performance, revoking his promise. So please allow me to cancel the contract. That is called suit for rescission. That is your right as a victim. Second, suit for damages. Damages are of many parts: ordinary damages, special damages, vindictive damages, liquidated damages, so on and so forth. Simply remember that ordinary damages are not recognized, right? Because ordinary damages are those damages which are not intimated in advance. Special damages are intimated in advance, therefore, they have to be compensated by party causing breach of contract. Third, we have liquidated damages. It is superior to special damages where the quantum of compensation to be paid is also prescribed well in advance. Are bhai, if you don't perform the contract within 1 month, you have to pay 10% compensation to me. If performance is delayed beyond 1 year, you have to pay 20% compensation to me. Like that, the quantum of compensation is also fixed in advance. It is called liquidated damage. Tomorrow it may come in examination, my dears. Remember this point. Similarly, vindictive damages, that is punishable damages. Example, check bounce case, right? So any damages caused in contract which attracts punishment are called dash. What do you write? Vindictive damages or punishable damages. Of course, there are many cases like nominal damages, damages for loss of reputation and all. You forget about that. Simply, this much you remember for crossing the bridge called your PG entrance exam with respect to part 1 of Indian Contract Act. So I think time is
Sir, yes,
lapsed.
sir.
Madam?
Yes, sir. Sir, time is already 8:15.
I'm sorry, sir.
Can we conclude, sir, within 5 minutes? Or
Sure, sir. Sure, sir. I will conclude, sir. Just give me 5 minutes. I'm
Yes.
sorry. It's
No
really
problem,
bad
no
manners that
problem.
I don't maintain the time.
No.
Really sorry for that. Yeah, friends. Special contracts is also there. Contract of indemnity, section 124, 125. Only 2 sections are given for that. Section contract of guarantee. Here, contract of guarantee comes only when principal debtor, principal creditor. That means only in the case of debt and credit occurs, guarantee contract comes into picture. Next, of course, we have contract of bailment. Simple example by bailment is nothing but you are giving your new cloth, new garment to tailor for stitching purpose. It's a contract of bailment. So, oh, I'm sorry. Someone please mute yourself for a minute. I will be done in 5 minutes. Right? So similarly, contract of agency. So if you are performing your contract through other person called agent, it's called contract of agency, discussed from section 181 to 238. Similarly, contract of pledge. What is this contract of pledge? You keep some physical property or gold ring or gold ornament and take a loan. It is called contract of pledge. Giving the physical custody and taking the loan is called contract of pledge. There are so many aspects to discuss, but Mallikarjun sir has cautioned me that time is lapsed. So, Sale of Goods Act, my dears, only few points I will cover, then I will be winding it up. Sale of Goods Act, you mainly remember the conditions and warranties. What's the basic difference between condition and warranty? Condition is a guarantee. If it is not fulfilled, you can cancel the contract of sale. But warranty is something which is not fulfilled. You cannot cancel the contract. Simply, you can claim compensation. Right? There's a difference between warranty and guarantee. So there are implied conditions. You please read that carefully. One is nemo dot quod non habet. That is, no one can convey better title than what he himself has. That means condition as to ownership. Condition as to quality and fitness. Here you have to see what is doctrine of cave tempter also. Let the buyer beware. No doubt, you have to see the quality and fitness sold by the seller. At the same time, whether it fits for you, suits for you, you must decide. It's called doctrine of cave tempter. Condition as to merchantability, condition as to package. There are so many conditions that I request you to clearly see before you go for examination. And you please also see who is unpaid seller and what are his rights. Section only. Section 45, subsection 1 defines unpaid seller. That is sufficient in Sale of Goods Act. And last one, Consumer Protection Act, where you see who is a consumer. Remember that consumer is only end user, not a intermediary, not a person who buys the goods for reselling purpose or rebuilding purpose. Only end user is called consumer. There must be consideration. If you buy the goods or pay rent for the goods, then only you are a consumer. Mind it very clearly. And of course, you remember that there are three types of judiciary bodies in consumer protection, three types structure. That is district forum, state forum, and national forum. I will give only the previous or the old law, 1986 law, because your examination will be conducted on the basis of existing law. That is 1986 law. So district forum will have 3 members, which will entertain disputes of consumers up to 10 lakhs rupees. State forum will have 3 members, will entertain cases from 10 lakhs to 1 crore. National forum will have 5 members, will entertain any cases about 1 crore rupees of consumer disputes. Of course, these figures are now changed. The new Consumer Protection Act changes that. And of course, finally, Companies Act also there in the syllabus. Simply, you go through how to appoint director. That is the turnover criteria for appointing woman director, turnover criteria for appointing independent director, turnover criteria for appointing small director. These technicalities you just go through once, then you appear for your examination. So with this, I am done, sir. I'm extremely sorry that I took 20 minutes excess than what is given to
No,
me.
sir, no, sir, no, sir.
Hope I am done, sir. I have touched all the
Yes, sir.
aspects now.
Excellent, sir. Excellent, sir.
Thank you so much, sir.
Thank you, ma'am. I'm done.
Thank you, sir. Nothing, sir. You did very good. Now,
you.
on this occasion, I request Rifat ma'am.
Yes, ma'am.
Rifat ma'am, are you-
Nagalakshmi ma'am, Nagalakshmi ma'am.
Yes, sir. Yes.
Yes, yes, ma'am.
Yeah. Shall I proceed, sir?
Yes, ma'am. Wait 1 minute, ma'am. I thank Suresh sir for accepting my invitation without any hesitation.
My
and
privilege, sir.
To attending the college and giving the lecture same day.
Thank
Sorry
you.
for troubling you, sir. Sorry for troubling.
Nothing, sir. Nothing.
So we